Welcome to this video series on ethics in Horizon Europe, produced by the Ethics and Research Integrity sector of DG Research and Innovation. In this video series, we will briefly explain to you the ethics appraisal process for Horizon Europe and introduce the ethics issues that activities, in particular research activities, may raise and how these must be addressed. The ethics appraisal process has been put in place to ensure that all activities funded under Horizon Europe adhere to fundamental ethical principles, respect human rights and basic EU values as foreseen in the Horizon Europe regulation. More specifically, the ethics appraisal process is designed to protect all those involved and impacted by research and related activities. This includes the research participants, but also the researchers, animals, the environment, and society as a whole. Secondly, the process aims to support researchers, help them to adopt an ethics by design approach. Furthermore, as ethics is an essential element of research excellence, the ethics appraisal process contributes to upholding the trust of society in science. The ethics appraisal process begins with the ethics self-assessment provided by the applicants when submitting their application for funding. For proposals that pass the scientific evaluation and are on the main list or shortlist for funding, the funding agency, the ERC, REA, HDEA, ESMEA, or any other joint undertaking, organizes an ethics evaluation. For the ethics evaluation, an ethics pre-screening, screening, and for proposals raising serious or complex ethics issues, an ethics assessment will be organized. Each step of the ethics appraisal process uses the same ethics issues table. The ethics issues are the use of human embryonic stem cells in human embryos, the involvement of humans in the activities, the use of human cells or tissues, the processing of personal data, the involvement of animals, the involvement of non-EU countries in the activities, concerns regarding environment, health and safety, the use of artificial intelligence-based techniques, and a broader category of other ethics issues, and a cross-cutting issue being misuse. Depending on the type of the call, the number of proposals received, and the likelihood that the proposed activities raise serious ethics issues, an optional pre-screening exercise may be organized. The sole purpose of the pre-screening is to clear efficiently all those proposals that do not raise any ethics issues at all. However, if one or more ethics issues are identified by the ethics expert or qualified staff members, the proposal has to go to an ethics screening. The ethics screening is a mandatory exercise for all shortlisted proposals, except, of course, those that are already cleared at pre-screening. The exercise is conducted by two ethics experts. In this exercise, the experts must determine all the ethics issues that are raised by a proposal, based upon the proposed activities, the methodology, and not just the ethics self-assessment already provided by the applicant. All the applicable ethics issues have to be flagged at this stage. In addition, to determine the outcome of the ethics screening, the experts must determine whether the ethics issues are properly addressed by the applicant and whether some of these issues might raise serious or complex ethics issues. In the latter case, proposals have to be transferred to an ethics assessment. If the issues are not serious or complex, or it is not clear whether the applicant will address the ethics issues appropriately, the appointment of an ethics advisor or board may be considered, as well as the recommendation to conduct an ethics check or ethics review during project implementation. Of course, if no issues at all are identified, proposals can receive ethics clearance also when all the issues are already addressed in an appropriate way. The ethics assessment is mandatory for all proposals involving human embryonic stem cells and human embryos, and of course all those proposals that raise serious and complex ethics issues. The ethics assessment is the most elaborate ethics review exercise conducted by 5 ethics experts and may result in ethics clearance. Of course, this is a very unlikely outcome at this point. Conditional ethics clearance, where specific ethics requirements are formulated, or proposals may be transferred to a second ethics assessment in the very exceptional and serious cases where a second assessment is needed to determine the ethical acceptability of the proposed activities. Most often, the ethics assessment results in the conditional ethics clearance, where ethics requirements are included as contractual obligations in the grant agreement. These can be obligations, for example, to change the methodology, to report on how ethics issues have been addressed, for example, in the form of ethics deliverables. Importantly, during the project execution, it is possible that the funding agency or the Commission organizes an ethics check or review to monitor ethics compliance of ongoing projects. In the next videos, we will introduce the ethics issues in more detail, and it will help you to understand and navigate the ethics appraisal process. To identify ethics issues in proposed activities, it is important to keep in mind the following 4 questions. First of all, what are the objectives of the proposed research? For example, the objectives can be to study certain vulnerable populations. Secondly, it's important to ask what the proposed methodology is. What methodologies can involve, for example, a laboratory experiment or the analysis of personal data. Third, it's important to ask what the materials and the resources are that will be used during the research activities and how exactly these will be obtained. Fourth, it is also important to consider the potential impact of the activities and the research, for example, on the environment, on animal welfare, or other risks of misuse, for example, when research results could lead to stigmatization. Of course, in addition to identifying the ethics issues, it's very important as expert that you also consider whether the applicable ethical and legal standards and principles are met. For more information on the ethics appraisal process, please consult section 13 of the Horizon Europe Programme Guide, which can be found on the Funding and Tenders portal. Additional information you can also find in the How to Complete Your Ethics Self-Assessment, the Model Grant Agreement, and of course the regulatory framework for Horizon Europe. Thank you very much for your attention. Welcome to this video series on ethics in Horizon Europe prepared by the Ethics and Research Integrity sector of DG Research and Innovation. The aim of the video series is to explain the ethics issues included in the ethics issues table that are used in all stages of the ethics appraisal process. In this video, we focus on the use of human embryonic stem cells or human embryos in Horizon Europe funded activities, in particular research activities. The use of human embryonic stem cells or human embryos for research purposes requires heightened ethical scrutiny because of the fundamental ethical tensions and debates and the diverging ethical and legal frameworks in the member states. Also because of the close proximity of such activities to activities that are not eligible for funding under Horizon Europe because of ethics concerns. Activities not eligible under Horizon Europe for funding are activities aimed at human cloning for productive purposes, activities intended to modify the genetic heritage of human beings, activities intended to create human embryos solely for the purposes of research or for the purpose of stem cell procurement. Research on human stem cells, both adult and embryonic, may be financed, however, depending on both the contents of the proposal and the legal framework of the member states involved. Importantly, activities that result in the destruction of human embryos, for example, for obtaining stem cells, are not eligible for funding either. There is indeed a very broad spectrum of laws and regulations across Europe. The laws and regulations in Europe on human embryonic stem cells and human embryo research vary from a complete ban on such research activities to a ban on derivation of human embryonic stem cells, but allow research on important cell lines. Some countries allow research on surplus embryos, and in some countries, the creation of research embryos is allowed. For the evaluation of research proposals involving human embryonic stem cells and human embryos, the scientific evaluators already give their opinion on whether a proposal involves the use of human embryonic stem cells or human embryos. This is independent of and serves to verify the applicant's answers in their ethics self-assessment. In addition to that, the scientific evaluators already evaluate the necessity of the use of human embryonic stem cells to achieve the scientific objectives of the proposal. So it will be very important to verify the scientific evaluation report when reviewing a proposal involving human embryonic stem cells or human embryos. When you verify whether a proposal involves the use of human embryonic stem cells or human embryos, it's important to keep in mind that induced pluripotent stem cells or any other type of adult stem cells are not included in this category. In addition, the secondary use of embryonic and fetal tissues other than human embryonic stem cells is not included in this category either. Also, organoids derived from stem cells in vitro are not included. To see whether human embryos are included in a proposal, it's important to bear in mind that this is not just a question of fertilization of viability. When a research proposal involves human embryonic stem cells, it must be compliant with the member state's legal framework. There must be a project-specific ethics approval in place. The scientific experts must confirm the scientific necessity of using human embryonic stem cells, and the proposal must comply with the agreed EU principles. These principles are, firstly, that the project only uses existing culture cell lines. Secondly, that these cell lines were not originally derived from embryos specifically created for research or by somatic cell nuclear transfer. Thirdly, it must be confirmed that those stem cells were derived from supernumerary non-implanted embryos resulting from IVF procedures, that informed consent had been obtained, that the personal data and privacy of the donors has been respected, and that no financial inducements were provided for the donation of the embryos. All these aspects are verified by a mandatory ethics assessment and by an additional approval procedure by the member states for all research that involves human embryonic stem cells. So, applicants must provide information on the origins of the cell line, provide details on the licensing and control measures in the member state in which the research will take place. Applicants must also register the cell line, the project, and potential subclones in the Human Pluripotent Stem Cell Registry, obtain ethics approval and any other relevant authorizations required by national law, and confirm their compliance with the 6 principles. Also, for research activities that involve human embryos, compliance with the member state's legal framework must be confirmed, a project-specific ethics approval must be in place, the scientific necessity must be confirmed, and the agreed EU principles must be verified. This means that the activities may not result in the destruction of the human embryo. The research activities may not use embryos created for the purpose of research, only non-implanted embryos from IVF procedures. Informed consent, of course, needs to be in place. The privacy and personal data of the donors must be protected, and no financial inducements must have been provided for the donation of the embryos. Again, this is verified by the mandatory ethics assessment and the additional approval procedure by the member states. So for human embryo involvement, applicants must provide information on the origins of the embryo, details on the recruitment, inclusion, exclusion criteria, and the informed consent procedures that were used, the informed consent forms and information sheets, copies of the ethics approvals and other authorizations, and the confirmation that the embryos will not be destroyed as a result of the activities. In the How to Complete Your Ethics Self-Assessment guidance note, you will find a detailed table including all the information that has to be provided and an overview of the documents that have to be in place. Thank you very much for your attention. Welcome to this video series on ethics in Horizon Europe prepared by the Ethics and Research Integrity sector of DG Research and Innovation. The aim of the video series is to explain the ethics issues included in the ethics issues table that are used in all stages of the ethics appraisal process. In this video, we focus on human involvement and participation in Horizon Europe funded activities, in particular in research. The importance of adequate protection of humans who participate in research or related activities can best be illustrated by looking at the history of research ethics. The Nuremberg Code, for example, was formulated as a response to the inhumane experiments conducted by the Nazi doctors and therefore emphasized the need to get voluntary consents and avoid all unnecessary suffering. In the US, the Tuskegee syphilis study provided an important impetus to strengthen research oversight. Unfortunately, also more recent examples, such as the Havasupai case, remind us there is a risk of harm and exploitation. In this case, genetic material of the Hasafubai tribe was collected in diabetes research that was in fact used for studies on schizophrenia, ethnic migration, and population inbreeding, taboo topics for this population and cultures for which the donors did not provide consent. In medical research, but also in social sciences and humanities, participation in research can involve risks. For example, there can be risks for health and well-being. In the social sciences, well-being could also be affected, for example, where research addresses sensitive topics that may cause the research participants stress and anxiety, or when their participation in research would be disclosed could lead to social exclusion. Beyond social and relational risks, risk may also be of economic or even legal nature. This could be the case, for example, when research involves political dissidents or other groups that may be subject to prosecution, such as ethnic or religious minorities. One of the main goals of ethics review is to protect the research participants and to ensure that the risks they are exposed to are effectively mitigated. Therefore, whenever humans are involved in research activities or related activities, this has to be flagged as an ethics issue. To determine whether this is the case, it is very important to verify the proposed methodology. The proposed activities may, for example, include surveys, questionnaires, interviews, but also clinical interventions, donations, recordings, behavior observations or online observation, other types of examinations. Importantly, it is not because human involvement is flagged as an ethics issue during the ethics evaluation that this means that their involvement is not adequately addressed or raises serious ethical concerns. On the contrary, issues are flagged to make sure that they don't become a problem. In this context, it's also very important to be aware that research participants are not always aware of the fact that they are part of research. For example, in cases of group observation, or when there is a methodology that involves deception or covert research, which can be very important for psychological experiments or for criminological research. In addition, research participants may not always consider themselves as being research participants. This is very often the case when employees are used to develop and test certain new systems or applications, for example, biometric identification systems. If humans are involved in research, how must it be addressed? Research ethics is most developed as a concept in medical research, but the general principles apply for all fields of research. At all times, we must respect human dignity and autonomy, protect research participants' safety, well-being, and privacy, and ensure that they are not exploited by ensuring a fair distribution of benefits and risks. Respecting these principles requires a research design in which the burdens and risks are proportional to the value of the expected outcomes, that the risks and burdens are minimized to the extent possible, that there is prior free and informed consent, that the confidentiality and privacy are respected, and also that ethics approval has been granted by a competent independent ethics committee. For medical research, these principles are enshrined in important documents such as the Declaration of Helsinki or the Oviedo Convention on Human Rights and Biomedicine. Importantly, these documents also set further requirements, for example, that medical research should be conducted by medically or scientifically qualified individuals. In addition, various European, national, and regional laws may apply, including, for example, the clinical trial regulation. In social sciences and humanities research, there is generally less regulation, and most guidance is contained, for example, in codes of professional organizations. As mentioned, one of the key requirements is to obtain free and informed consent before enrolling participants in the research. This is sometimes legally required, for example, by the clinical trial regulation, but is always ethically required. There are only some limited exceptions, for example, when research involves covert research. It's also important to make a distinction between informed consent for participation in research and consent as a legal basis for the processing of personal data as foreseen by the GDPR. It's important also to take into account that informed consent is not just a form to be filled out and signed. It involves an entire procedure. This procedure involves informing the potential participants using information sheets or other types of methods. It's also important that there is a procedure in place to verify potential participants their understanding of the research, the risks and benefits involved. In addition, what is needed is a process that ensures the clear and unambiguous expression of their willingness to participate, which is also clearly documented. And it is very important to ensure that throughout the entire research process, their participation remains voluntary, thereby respecting their right to withdraw. To ensure this, the process must guarantee that the information is given in lay terms, that no pressure of any kind is involved, that the procedures are adjusted to the particularities of the research participants and their situation, that consent forms are written, dated, and signed, and that adequate time is given to the research participants or their legal representatives to consider the decision to participate. In the informed consent procedure, it will be very important that the information sheet adequately describes the aims, methods, and duration of the research, possible implications, the nature of the participation, and any benefits, risks, or discomfort that might result from it. It must also be disclosed, in particular in the clinical context, whether any alternative procedures for treatment and diagnosis are available, whether there are any genetic tests planned, and whether there are any treatments or compensation if injury occurs. In addition, information sheets must contain information on the insurance policies, state that participation is voluntary, and that anyone has the right to refuse and withdraw their participation at any time. In addition, information sheets must include information about the organization and funding of the research and include contact details of a contact person. It is also important to provide information on what exactly will happen with results of the research. In informed consent procedures, you will need to have particular attention to verify whether or not vulnerable participants may be involved. Vulnerable participants are generally considered when children, patients, members of minority communities, refugees, illiterate persons, or other persons at risk of coercion are involved in the research. In this case, it's very important to carefully assess whether the informed consent procedures are adapted to their needs and interests. In addition, it's very critical to look whether the risk-benefit balance of the entire research process is appropriate for their needs and interests, and that risks of coercion and undue inducement are effectively mitigated. Children and other persons unable to give informed consent should only be involved in research if the research results can only be obtained by involving those groups, participation only involves minimal risks, and the research directly benefits the participants and/or the group that they represent. In some exceptional cases, informed consent can be given by a legal representative, such as a parent in the case of children involvement in research, or a guardian. Whenever possible, assent by the participant should be sought and their dissent should always be respected. Exceptionally, informed consent for participation in research may be based on advance directive, for example, when involving the collection of biological materials after death, or retrospective consent may be sought, for example, when research involves deception. Oral consent procedures may also be considered in exceptional cases where documenting and signing consent forms may jeopardize the anonymity and expose research participants to various risks. This can be the case, for example, for research involving political dissidents or communities at risks of prosecution. In the How to Complete Your Ethics Self-Assessment guidance, there is a detailed table indicating for the different types of research and participants what information applicants have to provide in their ethics self-assessment and what documentation they should keep on file. Importantly, this is not just a tick box exercise. When you are reviewing proposals, you must assess not only whether certain information is provided or documents are in place, but whether this is adequate from the ethical point of view. In general, the information that will have to be provided for all research involving human participants are inclusion and exclusion criteria. For example, for patients, what diseases, conditions, and disabilities do they have? Or in social media research, how it will be ensured that children are not involved. Justifications for including vulnerable groups or children or other groups unable to provide informed consent, recruitment procedures, compensations offered, a risk assessment of the technique used, especially when research involves invasive techniques, and procedures to mitigate pain and discomfort also have to be described. It's also important that you verify whether procedures and templates for informed consent are in place and whether an adequate incidental findings policy has been provided. Importantly, for activities that involve the conducting of a clinical study, a separate annex is included where essential information involving clinical studies has to be provided when submitting your application. Additional guidance note on the involvement of humans in research can be found in the How to Complete Your Ethics Self-Assessment. For example, dedicated guidance is available for anthropological research, for research involving refugees, asylum seekers, and migrants, for social sciences and humanities research, for research with the potential for human enhancement, and also for clinical trials with pediatric populations, and so forth. Thank you very much for your attention. Welcome to this video series on ethics in Horizon Europe prepared by the Ethics and Research Integrity sector of DG Research and Innovation. The aim of the video series is to explain the ethics issues included in the ethics issues table that are used in all stages of the ethics appraisal process. Here we focus on the use of human cells and tissues in Horizon Europe funded activities, in particular research activities. The category human cells or tissues must be selected in the ethics issues table for the use of all types of biological samples of human origin. This includes blood, gametes, bone marrow, stool, organs, plasma, skin, cells, hair, sweat, and so forth. This also includes fetal and embryonic cells or tissues other than human embryonic stem cells, for example, coming from donations after pregnancy terminations. This category also includes induced pluripotent stem cells from somatic stem cells and other type of adult stem cells such as umbilical cord stem cells or bone marrow derived stem cells. In this category is also included organoids that are derived from induced pluripotent stem cells or human embryonic stem cells. The use of all those types of cells or tissues is often essential for medical research, but also raises various ethical concerns. In addition to the ethical concerns that may arise when the samples are initially collected, the donors of the cells or tissues involved often sense an identification with the cells or tissues. These cells or tissues may also reveal information about the donors, for example, regarding their health, but also contain genetic information that may be revealed. In addition, concerns may arise regarding compensation, for example, when commercial applications result from research on particular cells or tissues. Cells and tissues that are used for the purpose of research may be obtained from commercial sources, from another project or laboratory, or from a biobank. Irrespective of the source of the cells and tissues, it is essential that there is free and informed consent for obtaining those cells and for using them for research, and that the confidentiality of the donors is respected. Please note that when biological samples are collected for the purpose of a research project, also the second category, the involvement of humans, applies, should be identified as an ethics issue, and the relevant ethical principles complied with. Please also be aware that preserving privacy of the donors might be particularly challenging when samples are genetically sequenced. When research proposals include the use of human cells or tissues, it's firstly very important that the informed consent of the donors is in place and covers the proposed activities. This can be the case that samples come from earlier research projects, then it's important that the initial consent also covers the research that is proposed. When samples are collected within the clinical practice context, it's important that also the patients consent to the use of their samples or tissues for research purposes. Information that has to be included in the information sheets is how long the samples will be stored, for what types of research it will be used, whether or not the samples will be pseudonymized or anonymized, whether genetic sequencing techniques will be used, and when there is a risk of incidental findings, how these will be reported back to the research participants or donors. In addition, it must be mentioned how long the samples will be stored and when and how they will be discarded. Secondly, it's very important that the privacy and confidentiality of the donors is adequately protected. Please be aware that when genetic information is also stored, that particular additional measures may need to be taken to ensure their privacy. Thirdly, all proposals must comply with relevant legal frameworks. For example, compliance with EU Directive 2004/23 on tissues and cells, but also with other relevant national laws and regulations. Certain licenses and authorizations might need to be in place for establishing a biobank and for storing human body materials, for transferring and for importing and exporting such materials. For all types of pluripotent stem cells, registration of the cell lines and the project in the Human Pluripotent Stem Cell Registry is also important and required. It will hence be very important to always verify whether the initial consent for the use of the samples for research also covers the proposed research, in particular when genetic sequencing activities are foreseen. Very often, research participants or patients or other donors provide a broad consent for the use of their cells, tissues, or samples for research. This can be acceptable when there are only minimal to non-existent risks involved. When there are higher risks, especially increased by genetic sequencing, a more specific consent is necessary. Key information that applicants have to provide is details on the source of the materials, details on what will happen with the materials at the end of the research, a confirmation that the samples are fully anonymized, or that consent for secondary use has been obtained. If the material is collected within the project, also the informed consent procedures, the amount collected, and the procedure of collection must be provided in addition to an ethics approval for the collection. If the material is intended to be stored for further use in other projects, it's also important that the consent for such storage is provided, that the legislation is stated under which the material will be stored, and how long the material will be stored, and what will happen with it at the end of the research. In the How to Complete Your Ethics Self-Assessment Guidance note, there is a detailed table including for all types of research and sources of cells and tissues the information that the applicant has to provide and the documents that they have to have in place. Thank you very much for your attention.
Hello, my name is Michalis Kritikos and I'm a policy analyst at the Ethics and Research Integrity sector of the Directorate General for Research and Innovation. Today, I'm going to talk to you about data protection, privacy, and how these issues are treated within our ethics appraisal procedure. Data protection and personal data is one of the most important aspects of our procedure. It is both a central issue for research ethics in Europe, but also a fundamental human right. Data protection is by far the most ticked category in our ethics issues table. The right to data protection is enshrined in the EU Charter for Fundamental Rights, but also in the Treaty for the Functioning of the European Union. Several data protection structures have been established at the EU level, and data protection national authorities have been also established at the national level throughout Europe. What is personal data? Personal data is any information related to an identified or identifiable directly or indirectly natural person. Personal data processing refers to any operation such as collection, recording, organization, storage, or destruction of data, personal data. By identifiers, we refer to names, identification numbers, location data, online identifiers, and also any information that relates to the physical, psychological, genetic, mental, economic, cultural, or social identity of a specific individual. Personal data includes data such as internet protocol addresses, and data from smart meter monitoring energy usage, and anything that may end up distinguish an individual from a data protection perspective. There are special categories of personal data that are considered to be sensitive and require a different ethical approach. These are genetic data, biometric data, data concerning health or data concerning a natural person's sex life or sexual orientation. Personal data that reveals racial or ethnic origin, political opinions, religious or philosophical beliefs, or even trade union membership. What are the main potential risks and harms in the context of personal data processing? Exposing identity and sensitive data, security, safety risks for the research participant, harms to the interests and the well-being of the research participants, potential for misuse of data in terms of discrimination and stigmatization, but also those types of research activities that involve personal data processing, even when personal data analysis is not a key aspect of the methodology. It needs to be highlighted that not all risks or harms are linked to data breaches. Most of these risks also arise because of the lack of a clear understanding of the legal environment, where the research is going to take place, or the differences between anonymization and pseudo-anonymization. Sometimes there is an excessive collection of data and an unjustified storage period indicated. As you may know, the European Union has adopted a general data protection regulation that imposes certain obligations and also ethics requirements on the research community. In that sense, research proposals must demonstrate compliance with GDPR in terms of the lawfulness, fairness, and transparency of the data processing operations. They need to comply with purpose limitation, data minimization, accuracy, storage limitations, security, and accountability obligations. So in that sense, applicants are expected not to collect or not to process personal data that they don't really need, in accordance to the data minimization principle. However, our procedures are not necessarily limited to the evaluation of the compliance of the research protocol to the GDPR. Legal permissible research doesn't necessarily mean that it will be deemed ethical for our procedures. So, what is expected from our applicants and our ethics evaluators? We need to make sure that there is a compliance with ethical principles, the principles of human dignity, the respect of persons, the do no harm principle, beneficence, confidentiality, informed consent procedures, fairness, transparency, and accountability of the data processing, and also that there is an ethics risk assessment performed so as to assess risks for individuals as well as potential harms for third parties and group level harms. If personal data is processed, then we need an explanation on how all of the data intended to be processed is relevant and limited to the purposes of the research project. We also need detailed information on full and free informed consent procedures in accordance and to the GDPR, but also this information should be accompanied by templates of the informed consent forms and the information sheets that are going to be used. Data should, whenever possible, be processed anonymized or pseudo-anonymized form. There are higher ethical risks in specific, let's say, uses of personal data. When we have processing of special categories of personal data, when we have processing of personal data concerning children, vulnerable people, or people who have not given their consent to participate in the research, when we have complex processing operations and the processing of personal data on a large scale or systematic monitoring of a publicly accessible area, when we have data processing techniques that are invasive and deemed to pose a risk to the rights and freedoms of research participants, or techniques that are vulnerable to misuse. Also, when there is a collection of data outside the EU, or there is a transfer of personal data collected in the EU to non-EU countries with inadequate data protection regimes. We consider serious and complex cases from a data protection perspective when we have covert observation or deception of research participants that are collecting sensitive or special category data, or when we have data collected from closed or private groups on social media platforms, when we have covert activity trackers on sensors in connected devices, processing, data collection and data processing that poses threats to the data subject's physical safety, loss or of business or employment opportunities, humiliation or damage to the reputation and to the relationships. For that reason, one of the ways to address data protection risks of legal and ethical nature are the so-called pseudo-anonymization and anonymization techniques. These are not the same thing. Anonymized techniques means data that has been rendered anonymous in such a way that the data subject can no longer be identified, therefore it doesn't fall within the scope of the GDPR. Pseudo-anonymized techniques refer to those techniques that divide the data from its direct identifiers so that linkage to a person is not only possible with additional information. So this type of techniques refer to data that fall within the GDPR framework and need to be addressed in the way that is going to be explained in a few minutes. The issue of informed consent is of particular importance. We are expecting the applicants and the reviewers to verify whether consent has been provided in a free, voluntary, and informed manner, whether the purposes of the processing in question, the identity of the data controller, and for how long the data will be kept for are detailed and explained in advance. Special attention needs to be paid to big data analytics, to the use of data from those social media platforms, and to the use of data collected by commercial organizations for research purposes. There, the issue of informed consent becomes even trickier, and there is a need of higher attention to be paid from a data protection perspective. So the consent needs to be freely given. The issue of imbalance between the data controller and the data subject needs to be carefully assessed. Whether the consent can be withdrawn as easy as it is given needs to be also looked at and substantiated. The specificity of the consent is an issue of particular importance, so the scope of the given consent needs to be detailed, and the possibility to the consent only to certain areas of research or parts of the research needs to be verified. Informed consent refers to whether the consent is given on the basis of a clear and plain language provided and used throughout the informed consent process, and whether it is clearly distinguishable from other ethical issues. And the unambiguous character of the consent refers to whether the consent is absolutely clear by all means. An issue of particular importance from a data protection perspective is the issue of profiling, which is any form of automated processing of personal data that evaluate the personal aspects or behavioral aspects and analyze or predict aspects concerning a specific individual. So there are specific data subject rights that need to be respected for users and research subjects to know about the existence of the profiling and its possible consequences, to understand the logic behind the decision making, to be able to object or to opt out of the profiling, and to also contest and seek human intervention in respect of the automated decision reached. This is particularly important in the domain of artificial intelligence and big data analytics. The issue of international transfers of personal data is of paramount importance from an ethical perspective. EU member states' derogations under the national legislation are important to be looked at. Privacy and data protection laws of non-EU countries need also to be assessed, and adequacy decisions, if there are any, need also to be respected. There are possible legal biases for data transfers. The so-called adequacy decisions signed between the EU and non-EU countries. The appropriate safeguards that could be embedded in the research protocols that allow data transfer agreements with standard contractual clauses or binding corporate rules or authorized administrative arrangements. And also the issue of explicit consent that might provide a legal basis for derogating from the standard data protection framework. GDPR brought forward several concepts and mechanisms that are nowadays used in our procedures, and we're expecting the applicants and the reviewers to take stock and to somehow follow the logic of the regulation in order to be able to comply with the legal obligations, but also go a bit further and make sure that data protection and privacy from an ethical perspective are also respected. So in that sense, reviewers may ask the applicants to provide and to perform data protection impact assessments, to follow an accountability-based approach, to follow a data protection by design and by default methodology, to comply with the so-called data minimization principle, to embed and to adopt and to hire a data protection officer for their operations, and also follow a risk-based approach, the approach upon which GDPR has been established. So there is a manual and a sequence of steps that could be followed throughout the process of complying with the data protection norms. The first question that needs to be looked at is whether research involves the collection or the processing of personal data. If yes, then standard requirements need to be incorporated. If not, then there is no need to proceed any further. If personal data is processed, then there is a need for the description of the technical and organizational measures that will be implemented to safeguard the rights and the freedoms of the data subjects or the research participants. But also, there may be a need for a description of the anonymization or pseudo-anonymization techniques that will be implemented, and a description of the security measures that will be implemented to prevent unauthorized access to personal data or equipment used for research purposes. Moreover, we also need an explanation on how all of the data the applicants or the beneficiaries intend to process is relevant and limited to the purposes of the research project, following the so-called data minimization principle. There is also a need for an explanation why the research data will not be anonymized or pseudo-anonymized, whether there is a detailed information provided on the informed consent procedures with regard to data processing, and also we need to have a look at the templates that are going to be used for the process of informing and obtaining the consent of research subjects. There are also some other possible requirements that could be used if personal data is processed. These are the confirmation by the host institutions that they have appointed data protection officer, the so-called DPO, contact details of the DPO, whether a data protection policy, a detailed data protection policy for the project must be elaborated, and also, depending on the severity of the risks, whether other mechanisms need to be installed. The second question, the second step of the process, raises the question whether the research involves the processing of special categories of data, previously called sensitive data. In case sensitive data or special categories of data is used, then specific requirements will be incorporated and introduced, such as a detailed justification for the processing of these special categories of personal data. The beneficiary should also check if special derogations relate to the rights of data subjects or the processing of genetic, biometric, or health data have been established under the national law, and also submit declarations of compliance. The third step of the process involves the question about whether the research involves profiling, systematic monitoring of individuals, or processing of large scale of special categories of data that may result in high risks to the rights and freedoms of the research participants. If that is the case, then the applicant or the beneficiary needs to explain as to how the data subject will be informed of the existence of the profiling, its possible consequences, and how their fundamental rights may be and should be safeguarded. In that sense, a data protection impact assessment needs to be performed, and if that is combined with AI techniques, or you may also think of introducing a human rights impact assessment for that purpose. The fourth step of the process raises the question about whether research involves further processing of previously collected personal data, an issue that is very frequently arising in our procedures. If that is the case, then we're expecting the applicant or the beneficiary to provide an explicit confirmation that the beneficiary has lawful basis for the data processing and that the appropriate technical and organizational measures are in place to safeguard the rights of the data subject. The issue of data imported by non-EU countries into the EU is of particular importance, as mentioned before. So in such a case, then we need a confirmation that such transfers comply with the laws of the country in which the data is going to be collected. If data is planned to be collected in the EU, planned to be exported to non-EU countries, then we firstly need to give a look at whether adequacy decisions have been signed between the EU and non-EU countries, and whether there is an international agreement or any other agreement that allows the transfer of this data in accordance to Chapter 5 of the General Data Protection Regulation. There is a seventh question that relates to whether research involves the processing of publicly available data found in social media platforms. If that is the case, then we need an explicit confirmation that the data used in the project is publicly available and can be freely used for the purposes of this project. The issue of the high ethical risks that data processing may expose certain research participants to is of particular importance. In that sense, we are expecting the applicants or the beneficiaries to evaluate the ethics risks related to the data processing activities, and this includes also an opinion of whether a data impact assessment needs to be conducted, and this risk evaluation and the opinion must be submitted as a separate deliverable. There are several key sources and materials in the field of data protection, and in our web space, you are going to find documents produced by the European Data Protection Board on several aspects of data processing, on the processing of personal data for scientific research purposes, or a legal study on the appropriate safeguards for the processing of personal data for scientific research. And also, we have posted the legal framework, the legal documents, the regulations and directives that relate to the processing of personal data, guidelines, recommendations, and best practices adopted by the European Data Protection Board, a handbook on European data protection law issued by the European Union Agency for Fundamental Rights and the Council of Europe, and also our own documents, guidance notes produced on ethics and data protection in research projects, and any other document that we think is necessary to provide additional information and facilitate the work of both the applicants and the reviewers of projects from an ethical viewpoint.
Hello and welcome to this presentation about ethics issues regarding the use of animals in research. My name is Leonard Engels, and I'm a policy officer at the Ethics and Research Integrity sector of the Directorate General for Research and Innovation. If the scientific evaluation of the proposal agrees that the use of animals is necessary, then the ways and procedures in which these animals are used are subject to ethics evaluation. The measures for the protection of animals to be used for scientific or educational purposes are established in Directive 63. The directive covers a range of issues, including animal procurement and purpose breeding, animal use, where, how, and by whom, the licenses and authorizations that need to be obtained, the records to be kept, appropriate care and accommodation, the competences of those involved in research, recognizing suffering in animals and setting limits to that suffering, methods of end of life, reuse or continued use, and specific provisions for the involvement of non-human primates, dogs and cats, as well as the involvement of endangered or wild animals. Lastly, it also covers the responsibilities and oversight of national authorities. So what licenses apply or need to be obtained? The authorizations for the premises, for the user as well as the breeder, the project licenses, and personal licenses for the carers and researchers that are involved. Please, as an ethics reviewer, check that the licenses and authorizations and ethics approvals cover all the animals used, that they are up to date, and that they cover the research activities and the period for implementation. This may sound trivial, but some proposals include authorizations for different scopes or that do not cover the entire duration of the experiments or only cover some of the locations or species. What else should you look out for? The numbers and species of animals are covered by the national evaluators of the proposal, but you want to make sure that there is a justification. So you don't need to check whether the calculation is appropriate. You should just check that there is a justification for the numbers of animals that are being used. Also, authorizations for animal procurement and purpose breeding should be in place, training certificates and licenses for staff, authorizations in general for the animal experiment, and the corresponding ethics approval if available, covering, as I said, the entire scope, duration, location of the research and the species involved. And then, if necessary, appropriate authorizations for cloning or for genetically modified organisms. On top of that, there needs to be justification for the inclusion of non-human primates, and if non-human primates, dogs or cats are involved, then for these animals, personal history files need to be kept. These personal history files include the identity of the animal, the place and date of birth when available, whether the animal is bred for use in procedures, and in the case of non-human primates, whether it is the offspring of non-human primates that have been bred in captivity. Also, there needs to be included a list of any relevant reproductive, veterinary, and social information on the individual animal, as well as a list about all of the projects in which this animal has been involved. You should also check for justification for research on endangered or wild animals, including the responsibilities and involvement of oversight bodies, and descriptions of animal welfare procedures, including care and accommodation, recognizing suffering, setting limits, reuse, continued use, and so on. And for this, it is extremely important that also the adherence to the 3 Rs are described for replacement, reduction, and refinement. The principle of the 3 Rs aims to minimize animal suffering. The first R, replace, stands for replacing an animal by an alternative method or testing strategy, such as non-animal models and computer simulations or in vitro modeling, replacing live animals by tissues and organs from dead animals, or in the case of medical education, for example, replacing live animals with dummies. Also, higher animals should always be replaced by lower animals. The second R, reduction, means that the number of animals that are involved in the research should be reduced to a minimum that is necessary to achieve the scientific objective. And the third R, refinement, means that breeding, accommodation, and care should be refined, as well as the methods for minimizing pain, suffering, distress, and potentially also lasting harm to the animals. Some people now also speak about a fourth R. That could be for rehabilitation of the used animals, for reproduction, or more generally for responsibility. Please, as an ethics reviewer, be mindful of vague statements, for example, about numbers and species, such as, we will use 3,000 imported mice and 50 rabbits. Yes, why 3,000? Imported from where, by whom, why mice, why rabbits, and so on. Statements such as, we will ensure that we look after them well and feed them. Well, of course you will. That's your legal obligation. But you should provide information, meaning the applicant should provide information about how they are being cared for and about their accommodation and so on. Or statements such as, there are no plans to use any problematic species in this project. Well, the applicant is responsible for listing all of the involved species, and that's how you will see if any of the species are problematic or not. Endangered species are covered in Article 7 of Directive 63. It states that endangered species may only be used for specific research purposes, such as the preservation of the species or the avoidance, prevention, diagnosis, or treatment of debilitating or potentially life-threatening clinical conditions in human beings, animals, or plants, including the testing of drugs or foodstuffs for these aims. Non-human primates raise specific ethical concerns because of their proximity to human beings. So when is research with non-human primates allowed? Similar to endangered species, for the preservation of the species, but also for avoidance, prevention, diagnosis, or treatment of debilitating or potentially life-threatening clinical conditions in human beings, including the testing of drugs or foods for these aims, but also for certain basic research aims. The directive also states that if non-human primates are involved, as we already said, a personal history file needs to be kept for each individual animal. Also, non-human primates can only be involved in research if there is no viable alternative. Article 8 of Directive 63 states that wild animals shall not be used in procedures, and any exemptions must be granted by the competent authorities. If research is done outside of the EU, then a confirmation is needed that the research is compatible with EU and international legislation and legal in at least one EU member state. Attention should be paid specifically to the involvement of certain species of animals or certain methods of research, to the use of local resources, material transfers, or allegations of ethics dumping. The consortium must further confirm that the data cannot be collected in an accredited EU facility. For details on the involvement of non-EU countries, please refer to our presentation on that topic. The Arrive and Prepare guidelines include useful checklists for ensuring appropriate implementation of the 3R principle and good ethical conduct. This is again just an overview of the ethics self-assessment table, but please note that this chapter in the how to complete your ethics self-assessment is currently being revised, and the ethics self-assessment table will change slightly in appearance and wording in the coming months. For more information on the ethics appraisal process, please consult key resources and materials such as the Horizon Europe Program Guide, the How to Complete Your Ethics Self-Assessment Guidance, or the guidelines on serious and complex ethics issues. This concludes my presentation. Thank you for watching. Hello and welcome to this presentation about ethics issues regarding the involvement of non-EU countries in projects and research activities. My name is Leonhard Engels and I'm a policy officer at the Ethics and Research Integrity sector of Directorate General for Research and Innovation. It is relevant to speak about non-EU countries because entities from many countries outside of the EU can receive funding under Horizon Europe, and even those countries that are not eligible for funding can still participate in projects and, for example, receive in-kind services or benefits other than money. So when are non-EU countries involved? That's when activities are conducted fully or in part in a non-EU country, or when participants or resources come from a non-EU country, or when material is imported from or exported to a non-EU country. Examples might be the involvement of a hospital in the UK for clinical studies, or a project that analyzes vegetation samples from Peru, or maybe a research project that buys genetic resources from a company in Switzerland. Note please that if a consortium member comes from a non-EU country, please clarify whether any personal data is transferred to that partner. Okay. A quick reminder that no funding shall be granted for research activities that are prohibited in all member states. This is a legal provision, of course, and not an ethical requirement. And the applicant is responsible for proving that their research is legal in the respective non-EU country, as well as at least one EU member state. However, if you are unsure about this, if not enough information is provided, then you will want to flag this during the evaluation. So what are potential ethics issues regarding the involvement of non-EU countries? This might be ethics dumping, for example, the exporting of unethical practices to lower income settings, or exploitation of people and/or local resources. There might be legal differences, for example, the UK's announced changes of gene editing rules that might make some research legal in the UK that is not legal in the EU. It might exacerbate other ethics risks, for example, those related to the safety of researchers or participants, or related to language barriers. For example, informed consent needs to be in a language and in terms that is fully understood by the participants. It might also entail some potential risks in research collaborations that have considerable power, resource, or knowledge imbalances. So let's talk about how to make projects beneficial for all. Any use of local resources must show respect for cultural traditions and share the benefits. And for low-income or lower middle-income countries, this is a requirement. And in that case, the Global Code of Conduct for Research and Resource-Poor Settings needs to be respected, which gives some guidelines on fairness, respect, care, and honesty in the conduct in these settings. Now, a quick interjection. You can find a list of low and lower middle income countries on the website of the World Bank. But if you're doing an ethical review, then the link to this list will also be provided in the review documents that you have. And just to complicate things a little bit more, benefit sharing is a different issue from eligibility for funding from the European Commission. So entities from low-income countries are automatically eligible for funding in addition to those associated to Horizon Europe and those countries that are specifically mentioned in a call text. This does not mean that entities from other countries cannot participate in a project, however, and it also does not mean that benefits cannot be shared with entities from ineligible countries as well. So regardless of whether a project partner receives funding or not, your assessment must be drafted under the assumption that the same rules and the same ethical standards apply to all partners. So that also means that we may impose ethical requirements that exceed the legal requirements in the respective non-EU countries. But just a reminder again, as an ethics reviewer, you're not responsible for ensuring legal compliance. That's the responsibility of the applicant. You should just have a look at whether all of the necessary information is provided. And so what can be shared? What is benefit sharing besides obviously money and funding that can be shared? Benefit sharing could mean also that local infrastructures are improved, for example, schools or research facilities. It could mean that the environmental protection is enhanced in that country or that sustainable research practices are shared. It could also mean that medical knowledge, diagnosis or treatments or technologies are shared. And it also means, and I think this is important, that the results of the research or summaries thereof are made available in the local communities in a language that is understandable. In certain circumstances, applicants need also to take heed of the Convention on Biological Diversity, which is a treaty that promotes the conservation of biodiversity and its sustainable use. And where genetic resources are involved, the Nagoya Protocol lays down rules for fair and equitable sharing of these. If there is a medical study that involves human subjects, then of course also the Declaration of Helsinki needs to be respected. So what is expected from applicants? Applicants should provide a clear overview of all non-EU activities, including descriptions of transfer of data and/or materials. There should also be a confirmation, explicit confirmation, that all activities are legal in the respective country and in at least one EU member state. Also, it should be confirmed that all the relevant ethics approval or authorizations are in place or will be in place before the respective activities start. So what should you as an ethics expert look out for specifically? Besides obviously a confirmation that the ethics approvals and authorizations are in place, you should also have a look out for import and export authorizations, for example, material transfer agreements or technology transfer agreements. And if genetic resources are transferred across borders, it may be mandatory under the law of the provider country to obtain an authorization for the transfer. Also, there should be an overview of all the types of local resources that are going to be used in the activities, and especially if low or lower middle income countries are involved, details about benefit sharing measures. Also, please make sure that appropriate safety measures of all those who are involved, staff and participants, are described. A quick interjection on safety in non-EU countries. Because of our personal experiences, we may be unaware of potential risks in other countries. Now, this doesn't mean that non-EU countries are necessarily less safe than EU countries. It just means that some of the risks present in those countries may be unexpected. So please, when you review a proposal, ensure that it includes an appropriate risk assessment and, if necessary, a risk mitigation strategy that answers questions such as, is the staff appropriately insured, and is potentially any special training recommended or necessary? Some examples of potentially unexpected risks are that, for example, in low and middle income countries, there are less than half of the world's vehicles, but these countries contribute to over 90% of the total number of road traffic deaths. So, for example, Thailand is now a popular tourist destination, but currently also in the top 10 of countries with the most deadly car accidents per capita. Another example might be that trying to access certain websites from some non-EU countries could present a risk, and researchers may not always be aware of this, and so there should be particular attention on these potential risks. What if there is no dedicated structure for providing ethics authorizations or approvals in the involved non-EU country? In that case, the appropriate local or national ethics structures in the EU could replace these authorizations, could give these authorizations instead. For example, this might be from a university committee of the project coordinator or any other of the research partners. It could be a relevant ministry of one of the involved EU countries or another relevant authority in one of those countries. However, it is important that even when no local ethics approval can be obtained, to always involve the local community appropriately. If the applicants state that there is no appropriate structure, neither in a non-EU country nor in any of the involved EU countries, then the conclusions of the ethics appraisal by the European Commission will be the binding legal opinion on this. This is just a quick look at the self-assessment table that all the applicants need to fill out, and you can find the link to this also in the Horizon Europe program guide. Here are some key sources and materials that might be beneficial for your ethics review, such as the Horizon Europe program guide, the How to Complete Your Ethics Self-Assessment, or the guidelines about serious and complex ethics issues. For more information on the ethics appraisal process, please consult any of these guidelines. This concludes my presentation, and I thank you for listening. Hello and welcome to this presentation on ethics issues with respect to the environment, health and safety. My name is Leonard Engels, and I'm a policy officer at the Ethics and Research Integrity sector of the Directorate General for Research and Innovation. Article 19 of the regulation establishing Horizon Europe establishes the right to physical and mental integrity of a person, the need to ensure high levels of human health protection, and the need to ensure the protection of the environment. Projects and activities could have adverse impacts on human health and safety, for example, on staff, research participants, or uninvolved third parties, or on the environment, for example, on flora, fauna, or protected areas, either as a consequence of the experimental design of the research, including also as a consequence of the technologies used, or as an undesirable side effect during or after the activity. So what to look out for in projects that involve the environment? In addition, obviously, to the applicable international, EU and national law, the precautionary principle must be applied, and legislation on nature conservation and pollution control must be respected. The precautionary principle means that whenever there is plausible scientific evidence for serious risks, the applicants must prove that, for example, a new technology will not harm the environment. Wherever there is a potential risk, this must be assessed and avoided or minimized. Where applicable, also the appropriate environmental authorizations must be sought. Specific authorizations might be needed, for example, when protected areas or protected flora or fauna is involved. If applicable to the proposal, the applicant needs to explain explicitly how they comply with these laws, principles, rules, etc. So it's not your duty to check whether the proposal is legally compliant, but you will want to check that all the necessary information is provided. And if you think that something is required by the project, but you cannot find it, or you don't find a reasonable explanation for why it's not there, then you will want to flag this as a potential issue during your review. So what to look out for in projects regarding health and safety? Again, in addition to the applicable international, EU, and national law, also legislation on public health control and safety at work must be applied. And this can involve, for example, legislation on food imports, consumer protection, or standards for exposure of workers to risks arising from physical agents. Where applicable, again, specific health and safety authorizations must be sought, and these might include those for genetically modified organisms or safety classifications of laboratories. Some examples about health and safety measures might include appropriate safety equipment for staff, that staff is carrying authorized ID when doing fieldwork, and that plans are in place for staying in contact. Local authorities should also be notified of any fieldwork. Potential risks should also be assessed for all work sites, and staff should be trained appropriately, and it should be ensured that sufficient staff is available to conduct all activities safely. A quick interjection on safety in non-EU countries. There are certain risks that may be unexpected in non-EU countries, which does not necessarily mean that non-EU countries are less safe than EU countries, but just that some risks are unfamiliar. For more details, please refer to our presentation on the involvement of non-EU countries. Lastly, certain materials present particular risks to the environment, health, and safety. For example, toxic chemicals, explosives, or new materials. For these, staff needs adequate training in storing, handling, and disposing of these substances, and the risk assessments need to be adequate. For radioactive material, storage, handling, and disposal are clearly regulated in all EU countries, and release into the environment of radioactive material is only allowed if there is demonstrably no alternative. This is a quick overview of the ethics self-assessment table that all applicants need to fill out, and which you can also find in the document How to Complete Your Ethics Self-Assessment. Here are some key sources of materials, such as the Horizon Europe Program Guide, the guidelines on how to complete your ethics self-assessment, and for serious and complex ethics issues. So, for more information about the ethics appraisal process, please consult these guidelines. This concludes my presentation, and I thank you for watching.
Artificial intelligence is a new item of attention and a new item of ethical scrutiny for our procedures. There have been many efforts throughout the last few years to address AI from an ethical perspective. Recent developments in computer and processing power, the availability of big data, and the development of sophisticated algorithms promise a number of positive benefits. However, at the same time, many important ethical challenges have been identified, and these concerns have prompted a rush towards the creation of a domain which is called AI ethics. AI ethics addresses issues such as privacy, data protection, transparency, explainability, and biases in data and algorithms. During the last few years, a wide range of principles and guidelines for ethical artificial intelligence have been adopted by multinational technology platforms, civil society groups, governmental agencies, academic and research institutions, professional associations, and international non-profit organizations such as UNESCO, WHO, OECD, UNICEF, WEF, and the Council of Europe. Despite an apparent agreement that AI should be ethical, there is an ongoing debate about both what constitutes ethical AI, the most vital ethical principles, and which ethical requirements, technical standards, and best practices are needed for their efficient realization. The assessment of all these documents show us that there is an emerging convergence around a set of values and value frameworks. At the EU level, the European Commission has put forward a distinctive approach to AI under the name trustworthy AI or human-centric AI that promotes the need to reap the benefits of AI while minimizing its negative consequences. Trustworthy AI is designed to alleviate potential harm as well as to permit accountability and oversight, but also increase EU's digital sovereignty by ensuring that the European users have more choices and control. Trustworthy AI has three components which should be met throughout the design of the system, the system's entire life cycle. First of all, it should be lawful, complying with all applicable laws and regulations. Secondly, it should be ethical, ensuring adherence to ethical principles and values. And thirdly, it should be robust, both from a technical and social perspective. Within this frame, a high-level expert group on artificial intelligence was set up by the European Commission that produced the so-called ethics guidelines for trustworthy AI. This independent group delivered this document in June 2018 as part of the Commission's AI strategy. The guidelines have a human-centric approach, identify 4 ethical principles: the respect for human autonomy, prevention of harm, fairness, and explicability, and put forward 7 core requirements: human agency and oversight, technical robustness and safety, privacy and data governance, transparency, diversity, non-discrimination and fairness, societal and environmental well-being, and accountability. These documents are in the public domain, and on top of that, the EU decided to translate these high-level principles into a functional system of rules and self-assessment checklists. The most important initiative towards this direction, towards the operationalization of EU's AI ethics requirements, is the so-called ALTI list that indicates a set of concrete steps for a self-assessment and aims to provide a basis for trustworthy AI self-evaluation. It is a practical tool that translates the ethics guidelines into an accessible and dynamic self-assessment checklist. It is used by developers and deployers of AI systems that want to implement the key requirements in practice. It supports the actionability of these key requirements and guides developers and deployers in implementing ethics principles in practice. For our procedures, for the Commission's ethics review and appraisal mechanism, AI has become a separate section already in our guide on how to complete your ethics self-assessment. It is a separate section in our guidance note on identifying serious and complex ethics issues in EU-funded research. And on top of that, we have developed a special guidance on ethics by design and ethics of use for artificial intelligence and dedicated ethics checks on AI-related projects. More concretely, AI has become a self-standing ethics issue. So AI is considered as an ethics issue in itself for all activities that involve the development, deployment, and use of AI-based systems and techniques, but also when AI-based systems are used as components of larger systems. So Applicants and ethics evaluators must always identify the issue and explain why it is not a valid risk or concern in that particular context. Moreover, it is important for applicants to ensure ethics compliance even in cases where the project doesn't develop in itself an AI-based system or technique. What is AI for our procedures? AI doesn't enjoy right now a precise and universal definition. And for that reason, there are several definitions of AI that have been adopted worldwide and are used for legal, ethical, regulatory, and governance purposes. However, it needs to be stated and clarified that AI is not necessarily identical to the so-called machine learning. Machine learning is only one tool of AI. Not all automation is necessarily AI, and one has to differentiate between what we call strong and weak AI. The definition of AI now has become one of the most controversial points of the ongoing EU policy negotiations. For our procedures, we have adopted the definition proposed by the high-level experts group on AI, and according to that group, AI is software designed by humans that acts in the physical or digital dimension by perceiving the environment through data acquisition. They interpret the collected structured or unstructured data, reason on the knowledge, or process the information that derive from this data, and decide on the best action to take. Beyond the issue of definition, the 7 requirements put forward by the high-level expert group that are endorsed by the European Commission are evaluated at both the scientific and the ethical evaluation stages. 6 out of 7 are evaluated during the ethics evaluation, and the technical robustness and safety is examined throughout the scientific evaluation stage. So basically, scientific experts are expected to answer a specific question. Do the activities proposed involve the use or development of AI-based systems and techniques? If so, can you assess the technical robustness of the proposed AI system as part of the excellence criterion? Technical robustness there refers to the technical aspects of AI systems and development and includes resilience to attack and security, fallback plan and general safety, accuracy, reliability, and reproducibility. The ethics experts are expected to take into account the assessment on the technical robustness when performing the ethical evaluation. Starting from the self-assessment stage, AI is expected to be explained in terms of the risks it may pose, and also how and whether detailed measures are in place to address these risks. The applicant must explain how potential bias, discrimination, and stigmatization could arise, and indicate how it will be addressed by taking some concrete steps that are included in the Ethics by Design guideline produced by the European Commission. On how to complete your ethics self-assessment, there are questions, specific questions that are related to AI and raise particular issues that the applicant needs to address. Detailed explanation of the measures set in place to avoid potential bias, discrimination, and stigmatization. Detailed explanation on how humans will maintain meaningful control over the most important aspects of the decision-making process. Explanation on how the presence of the AI will be made clear and explicit to the affected individuals and research subjects. Justification of the need for the development of the use of this particular technology, and the assessment of the ethics risks and a detailed description of the measures is set in place to mitigate a potential negative impact during the research, development, deployment, and post-deployment phases. So basically, the applicant is expected to explain on how the participants and the end users will be informed about their own interaction with the AI system, the abilities, limitations, risks, and benefits of the proposed AI system, the manner in which decisions are taken, and the logic behind them. Moreover, applicants are expected to provide details on the measures taken to avoid bias in input data and the design of the algorithms, and to explain as to how the respect of fundamental human rights and freedoms will be ensured. Additionally, there is a need for them to justify the need for using AI systems, to establish which specific functions are automated in the weapon system, if that is relevant, and also to provide detailed explanations on how the potential ethics issues will be addressed and the measures set in place to mitigate possible ethics risks. At the ethics screening level, as I said before, artificial intelligence is a separate item, a distinct section in the ethics table. So there, the applicant is expected to follow this binary approach and indicate whether an artificial intelligence system is going to be used or not. Our reviewers and our mechanism is most of the times erring on the side of caution. If artificial intelligence is used, then we simply tick yes, and then the screeners have to indicate whether an ethics mentor or advisor needs to be embedded into the project implementation structures, whether there is a need for ethics assessment in case of serious and complex issues, or even whether there is a need for ethics check for monitoring the implementation of the project until the very end. If the project goes for ethics assessment, then again, the experts are expected to provide requirements to check, to screen, and to assess whether the project is ethics ready, so there is no need for further requirements, or in case they think that there are risks involved and risks that may be posed at the later stage, then they could introduce requirements that need to be implemented before the actual activity takes place. There are some standard questions that need to be somehow replied and treated throughout the ethics assessment process. The most important of which is the following: does the activity include the necessary elements to prevent or mitigate the risks of human rights infringements, discrimination against people, significant negative social impacts, or other important ethics issues? So there, the experts are expected to evaluate the risks of the proposed activities and to evaluate whether the risk mitigation plan that is in place, that is expected to ensure that appropriate measures are set in place to prevent or mitigate significant negative social or individual impacts. Some of the main requirements are the following. People must be made aware that they are interacting with an AI system, that there are mechanisms installed for human oversight, transparency, and auditability of the system. The latter is extremely important for our ethics checks. That the system must be designed to avoid bias in input data and algorithmic design. That there is a need to comply with data protection and privacy principles, given that AI systems are data intensive. And also that the impact of the developed AI systems are assessed and that the system is designed carefully so as to prevent possible risks of harm on individuals, the society, or the environment. At the ethics assessment stage, applicants must explain also, and reviewers have to assess whether applicants have provided explanations on how potential bias, discrimination, and stigmatization could arise. And there, the expectation is that the applicants must indicate how these issues will be addressed throughout the life cycle of the project. To that end, there are some standard ethics requirements that facilitate the analysis and the assessment of the project, one of which refers to the human rights impact assessment, the need to perform such an assessment that includes detailed information on how respect for fundamental human rights and freedoms will be ensured, and also whether there is an explanation on the measures taken to prevent, avoid, and mitigate potential bias, discrimination, and stigmatization in input data. Another standard ethics requirement refers to the detailed explanation on how the research participants and the end users will be informed about their interaction with the system, the abilities, limitations, risks, and the benefits of the AI system, and the manner in which decisions are taken and the logic behind them. The human overview requirement is fulfilled and addressed in the following standard requirement: the detailed explanation on how humans will maintain meaningful control over the most important aspects of decision-making process, and also whether copies of ethics approvals for the research must be submitted before the start of the relevant activities. To that end, our services have adopted a guidance on ethics by design for AI that builds on the work of the independent high-level expert group and addresses issues, proposes methodologies on how to address ethical issues during research and development. The guidance incorporates ethical principles into the development process, allowing that ethical issues are addressed as early as possible. It identifies concrete measures on how ethics by design can be installed and implemented to any development methodology, and explains the specific tasks which must be undertaken so as to help the developers think about ethics while they are developing an AI system. The guidance note, the guidance on the ethics by design, introduces a detailed methodology that is somehow designed into several layers. The first layer relates to the principles that need to be followed, and the AI system is assessed against these principles so as to be assessed whether to be evaluated, and for the reviewers to understand whether this AI system could be considered as unethical if it violates certain principles. Then the principles are followed by ethics requirements. These are the conditions that must be met for the AI system to achieve the goals in order to be ethical in its functionalities, data structures, and in the process by which the system is constructed. After that, we have the ethics by design guidelines that are proposed by this guidance note. These are concerned with the process for creating the system. The guidelines are either implementations of the ethics requirements or broader guidelines for different stages of development of the system. Then we have the AI methodologies, that is a variety of methodologies used in AI and robotics projects, and they are distinguished by the manner in which the development process is organized. And at the very end, we have tools and methods that are very specific instruments used within the development process. Beyond that guideline, beyond that set of guidelines, the Commission has adopted another guidance note that is not AI specific, the so-called Serious and Complex Ethics Issues guidance note, that, however, addresses AI as a distinct item of scrutiny, and in that respect, it identifies high-risk areas and applications that involve AI systems. These are biometric identification systems, the administration of justice, law enforcement, migration, asylum and border control, access to education and vocational training, employment and worker management. These are areas where we think that AI is of high ethical risk, and stricter measures need to be incorporated and need to be implemented in order to prevent possible risks. The guidance goes further and identifies specific uses of AI where stricter ethics requirements need to be incorporated. These are the so-called surveillance technologies that are AI-powered, that may not be necessary or proportionate in a democratic society. The AI used in societal scoring, automated behavioral or psychological profiling that may violate human dignity or lead to stigmatization or discrimination against people that may be subject to this type of AI applications, and also systems and techniques that have the potential to lead to significant negative social impacts or significant negative environmental impacts. Also, there are categories of AI, potential AI use, that are also considered as serious and complex, and these are applications and uses that aim at replacing or influencing human decision-making processes in a way that is likely to impact affected individuals or circumvent the autonomy of those individuals, that can lead to new manipulative and exploitative social control practices, and it can also have harmful implications for human rights, subordinate, deceive, or even manipulate people. For further information, you can visit our website, and there you'll find all guidelines mentioned, the guidelines on ethics by design for AI, the guidance on identifying serious and complex issues, the assessment list for trustworthy artificial intelligence, the ethics guidelines for trustworthy AI as they have been adopted by the independent high-level expert group, the how to complete your ethics self-assessment that, as I said before, incorporates a separate section on AI, but also watch that space because in the months to come, we're planning to produce new guidance notes on specific aspects, ethical aspects of AI that are going to facilitate the work of both the applicants and of reviewers and evaluators on AI projects. As AI doesn't happen in a legal vacuum, I need to, at this stage, also refer to the fact that since April 2021, the European Commission has submitted a proposal for an AI Act, for an Artificial Intelligence Act, that is going to tackle the risks of AI. This proposal, that is now in the hands of the European Parliament and the Council, adopts the ethics guidelines proposed by the high-level expert group and seeks to eliminate or mitigate the risks of AI, supports public trust in these innovative technologies, and enhances the development and adoption of AI in the EU. The proposal is divided into 8 chapters and puts forward a risk-based approach that defines 4 levels of risks in AI: unacceptable risk, high risk, limited risk, and minimal or no risk. All AI systems are considered to be a clear threat to the safety, livelihoods, and rights to people will be banned, from social scoring by governments to toys using voice assistants that encourages dangerous behavior. Thank you for your attention.